Everyone should make a will before they die to assure that their property is distributed according to their wishes. A will is a written document that directs the distribution of your property at death and names someone who will care for and distribute that property. A will may also name guardians for your minor children. It's important that you become familiar with issues related to wills and estates. The Iowa State Bar Association has put this video together to provide you with information about terms and issues that may arise in connection with a will. It is not an attempt to provide legal advice, and in fact, the ISBA encourages you to consult with your attorney regarding your estate planning so that you can ensure that your family is protected. A will is key to clearly establishing your plan for distribution of your estate. A will can control the way in which heirs receive their bequests and reduce their tax liability. Good estate planning can save thousands of dollars in estate taxes. It can also make sure your children do not receive their inheritance before they're mature enough to manage it. If you have young children, a will can name someone to care for those children, which for most of us is our most important interest. Your attorney's advice can be invaluable as you make these life decisions. Remember that the legal requirements for wills may be different from state to state. If you die without a valid will, you have no control over where your property goes. Instead, the laws of the state of Iowa make that decision for you. According to these laws, your property will be distributed to your spouse, if he or she is the parent of all your children, or divided between your spouse and your children. If you have neither spouse nor children and have no will, your property automatically goes to your parents or siblings. Some people wonder what an estate plan is. An estate plan is a set of documents that includes your will and any additional documents created to plan for your death or disability. Such documents might include a trust, powers of attorney, or a living will. For a will to be valid in the state of Iowa, certain requirements must be met. The first is that the maker of the will must be at least 18 years of age or married. This person is also known as the testator. The next requirement is that the maker must be of sound mind or competent to make decisions. The next requirement is that the will must be written and signed by the maker in the presence of two competent witnesses who are at least 16 years of age, who also acknowledge in writing that they witnessed the signing of the will in the presence of the maker and each other. The last requirement is that the maker must tell the witnesses that it is his or her will that they are witnessing. Although not legally required, the will can be self-proved at the time it is made if the maker and the witnesses sign affidavits describing how the will was executed. Then it will not be necessary to find the witnesses and have them testify about the execution of the will when the will needs to be used. Remember that you do not have to have an attorney draft your will and help you execute it, but the assistance of an attorney can ensure that the will is valid and your estate will be distributed as you desire. The person you choose to carry out the provisions of your will is called the executor. You should name the executor in your will. It is also a good idea to name an alternate executor as a substitute in case your first choice is unable to serve. If you do not name a person who is willing and able to serve as executor, the court will appoint an executor for you. You are allowed to distribute your property as you wish according to Iowa law. But if you are married, there is a significant restriction. Iowa law says that you cannot completely exclude your spouse in your will. Even if you do, your spouse will be entitled to take a certain percentage of your assets. Once you have a valid will in place, the will is good until you change it or revoke it. You are free to make changes at any time. In fact, changes in life circumstances may dictate that changes should be made. Things such as marriage, divorce, birth, adoption, death, or change in the tax code may require an addition or correction to your will. In most cases, these changes can be reflected in a document called a codicil, which allows for the changes without actually redoing the entire will. The requirements for the codicil are the same as for the original will. In the event that changes are substantial, you may want to redo the entire will. Rest assured that a will may be changed as often as the maker wants, providing the maker remains of sound mind. In the event that you want to revoke a will, there are two ways to do it. The will can be canceled or revoked by the maker or at the maker's direction. A will is automatically revoked by executing another will. At no time can the maker revive a will that has been revoked except by re-executing the will or executing another will or codicil. So what happens when you die? How do the instructions in your will get carried out? A will goes into effect upon the death of the maker when it is filed for probate. Most property owned by the maker cannot be dispersed until the will is probated. Probate is a formal court procedure that occurs after the death of the maker of a will. Probate serves several important purposes. First, it establishes your will. Second, it allows the transfer of clear title to real estate you owned at your death. Third, it allows your estate to be distributed to your intended beneficiaries. Finally, it provides for payment of all debts and charges against your estate and ensures that any creditor claims are dealt with. It may be possible to avoid probate. However, whether or not the court system is used, certain documents must be filed and taxes paid to properly finalize a decedent's affairs. For these reasons, a lawyer should be consulted to walk your family through the necessary steps. Careful estate planning can save your estate and beneficiaries substantial administration costs and taxes. There are certain kinds of property that cannot be covered by your will. The first type is life insurance policies. The beneficiaries that you have named as part of your policy will be the people who receive the proceeds of that policy. It does not matter whom you have chosen to receive property in your will, unless you designate your estate as the beneficiary. This also applies to retirement plans. Benefits from your retirement plan will go to the people you have named as your plan beneficiaries. If you fail to name anyone, or the person named does not survive you, then your will may decide who gets your retirement benefit. Property which is jointly owned or owned as joint tenants will be inherited by the co-owner, no matter whom you have named in your will. The same is true of property with POD or TOD designations. It is important to understand how you own property, whether there are co-owners, and whether you have named a beneficiary. The last example is a living trust. The property you have placed in a living trust during your lifetime will go to the trust beneficiaries at your death, regardless of what your will says. It is advisable to make a will even if your estate consists of these kinds of property that pass outside the will. For example, if you receive a winning lottery ticket as a birthday present, your will would cover your unexpected winnings. Having a will is a fail-safe way to make sure all your property goes where you want it to. We hope that this video helps you understand the issues surrounding estate planning and your will. As you can see, there are many things to be aware of. The cost of a will can vary depending on the complexity of the will and the extent of your assets. But normally the expense is minimal compared to the benefits you and your beneficiaries receive from having a well-devised estate plan. The ISBA reminds you that you don't need to navigate these issues on your own. Consult with an attorney regarding your estate planning so that you can ensure that your rights and interests are protected.